Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. Today's video I want to talk about a recent success I had for a client involved in an accident, took a breath test over the legal limit. And this is a case where we were able to obtain a not guilty verdict despite a high breath test. The case was in Worcester County. So what led to the great result in this case? So I'm Mike DelSignore. I handle Massachusetts OUI cases all over the state. I do a lot of work out of Worcester County. And one of the things that I think people make a mistake is when they enter into a plea too quickly on a breath test case. So keep this in mind. A breath test is not automatically admissible into evidence in court. Additionally, there's some flaws with these machines. So a breath test, one, it's not a blood test. It's making a conversion of your blood alcohol to breath alcohol. So basically it's taking the breath sample and saying, based on these calculations, percentages called the partition ratio, now we get the blood alcohol rate. So there's science, math involved. It's not always accurate for everybody. There's something called an observation period. This observation period needs to be complied with, or the test results can be inaccurate. So you got three things that could affect a breath test. One, mouth alcohol. Two, assumptions the machine makes about you in terms of blood breath partition ratio. Body temperature could affect how a breath test result comes out. It could be artificially high if you have an elevated body temperature. Things like asthma, acid reflux, all can cause contamination in the sample. And they're only testing a small amount of your breath. So any error is going to have a major impact on the result. So a breath test, when you take a breath test and you're over the legal limit, you lose your license for 30 days, as my client did in this case. But we can have a hearing to try to get that breath test excluded from evidence. We had this hearing. We were able to get the breath test, what's called suppressed under the law, meaning they're not going to consider it in evidence. So it's almost like my client did not take it. So now the case reverts back to your traditional OUI where you have field sobriety tests, observations. And I was able to argue that based on the fact my client was polite, cooperative in booking, the fact that there's really no major observations of impairment, I was able to get the officer to admit my client did many things correctly on the field sobriety test, that all of that raised reasonable doubt. And that's one thing you need to keep in mind when you're charged with a criminal offense like OUI. First of all, first offense, it's a misdemeanor offense. Second, it's a crime that requires proof to the highest degree of certainty. So it's not enough that you were arrested. It's easy to get arrested if an officer smells alcohol, you do the field sobriety test, they're not perfect, fail or refuse a portable breath test, which is not admissible, but it'll be relevant to the arrest, or blow over 0.08 on a breath test, you're going to be arrested and be brought to court. But that's a long way from being convicted. So to prove a case beyond a reasonable doubt is the highest degree of certainty in the matters of human affairs. So that's a very different standard than what you face on the side of the road. So keep that in mind. I know people who get arrested, you're very stressed, you're good people. 98% of my clients are excellent people. You know, sometimes I have hardcore criminals, but people who are charged with OUI are just hardworking people who just were in the wrong place at the wrong time. And whether you made a mistake or whether it was an over-aggressive police officer, I'm here to give you a second chance, here to get your life back together, because I know the impact it has on your family, your job, and I'll do everything I can to move the cases as quickly as possible through the court system, while at the same time getting you the best result possible. So for many people, when you take a breath test that's over the legal limit, fighting the case is the right option, because I've won breath test cases where the breath test has come into evidence. And I was able to argue that things like the booking video, the field sobriety test, all of these things don't show someone impaired. And I was able to have my client found not guilty. So it's not rare or unusual for me to win a case where somebody fails a breath test. So not all cases can be won. Sometimes I would recommend a plea, but in most cases it's worth looking at all the evidence, making sure the government can get the test into evidence, and considering your options for fighting the case. In Massachusetts, our judges generally don't penalize people if they're found guilty after trial. If it's a first offense, they're generally not going to give you much different of a resolution than you would have gotten on a plea. So If you want me to evaluate your case, I'm happy to do so. Call, text anytime. I had a great result for a client out of Worcester County recently. This is very common. I've had a breath test suppressed in Lane Court recently, Waltham. Had a not guilty in Waltham on a breath test case. So this is what I do every day. It's my passion, helping good people get their lives back after being arrested for OUI. Happy to help you. Call, text anytime, 781-686-5924.